Welcome back to Autism Live. We're so lucky because we have the wonderful Bonnie Yates, who is a special education attorney, joining us right now via Skype. Bonnie is joining us from the law firm of Hirji and Chow, and we're thrilled to have her with us. Bonnie, tell us a little bit about Hirji and Chow.
Okay, really quickly, Hirji and Chow is a special education law firm. We sort of cover all the bases. We're a 6-attorney firm. We do disability discrimination. We do higher education for students in college. We do regional center services, and we do special education under the IDEA.
You guys are amazing. And then we have a disclaimer that you give at the beginning.
Our disclaimer is we're answering general questions about your legal rights. We're not answering specific questions about your specific situation. If you have a specific situation, you need to talk to a lawyer in your own state about your specific situation, and we would ask that you go to www.copaa.net. That's a good place to start to find an attorney in your state that may be able to answer your questions. If that doesn't work, check with the state bar in your state.
Very cool. So Bonnie, we've been talking about a very tough subject about when kids get injured at school and all the various different ways. None of us like to think about this, but it's really important for us to have this information so that we can act accordingly if something does happen. So
it is a really tough subject. I was just thinking before you said that it's a tough subject. A side note, adults get injured at school too, and sometimes parents are actually on the receiving end when they're told that their child has injured another child or an adult. And I will say that unfortunately, public schools are much more responsive if your child is injuring someone, particularly a staff person, than if your child is being injured.
Yeah.
And that's an unacceptable inequity.
Yeah.
We talked last time about some of the situations in which injuries at school occur, and there, of course, also is always going to be this extension of the school day if you are traveling, let's say, off campus to go to a school function. But generally speaking, we quickly go from talking about the kinds of injuries that students may receive on campus to talking about restraints and seclusion, because there's a really big gray area here in terms of what goes on versus what is legal. And we talked last time about the fact that the law is in flux in California and that it's not as strict as it needs to be. So one of the things we're going to talk about in a little while when we get to it is a more model program for how to deal with the need to use restraints as a behavior intervention, a safe way to do that, which would be using those kinds of techniques only in emergency situations when highly trained people can't come up with anything else to do.
Right.
We're not quite there yet, though. But you can see how there would be situations where there would be the use of restraints that would be legal. So what about a student that requires a car seat or a seatbelt type of restraint, and so on. So, quote, "There's no precise or scientific way to measure the number or extent of injuries to children or injuries to staff as a result of physical restraint and mental effects. As a result of this, the federal government and many states are considering policy development re the use of restraints." Well, it hasn't happened yet. Medicine has those standards, but education doesn't. Quote, "The lack of these commonly accepted written standards in the school, the use of physical restraints, leaves schools getting more susceptible to misunderstanding, improper implementation, and abuse. Many states have no guidelines or regulations, and there's no consistency within the states. But prone restraint, where you have somebody, down on their stomach, and you're restraining their arms behind their back and so on, is dangerous and has led to death for some students. So it's a very, very important area of the law for public schools to understand what their legal obligations are, and for that matter, private schools too. But most of these cases are public school cases. So I'm just going to talk to you about a couple of California cases, since we're in California, that maybe give you a sense of how these cases can roll out. This is an old case, Bartel versus Palos Verdes Peninsula School District from 1978, 83 Calap 3rd, 492, 1978. But Palos Verdes School District is still there and very much in business. In this case, a student who was 12, and probably some of his friends, gained access to a playground at Lunada Bay Elementary School through either an unlocked gate or a hole in the fence. The boys sustained fatal injuries from playing a dangerous game while on school grounds. And they don't tell us what that was. And I was trying to imagine what it was, and I really haven't been able to figure it out. Anyway, the family sought recovery from the school district on the basis that the school district maintained a dangerous condition, and the school district negligently failed to supervise and maintain the school property or to notify parents of the dangerous condition. The school district dismissed the failure to state a cause of action, and they dismissed the case because they said that parents hadn't come up with a viable cause of action, and the family appealed. So what the family was trying to do was establish that the school district had a special duty to protect this student even while school was closed. And the holding was, the issue was, does the school district owe a general duty to supervise all persons who utilize its playground or to secure the premises against persons who may enter and injure themselves therein? The holding was, the ruling was, no, a school district does not owe a general duty to supervise all persons who utilize its playground or secure the premises against persons who may enter and injure themselves therein. A school district's duty to supervise its playground depends upon the existence of a special relationship between the school and its students. Here, the Bartels did not claim that their son's presence on school grounds was in connection with the school activity which qualifies as such a relationship. Whether a duty exists requires a consideration of several factors, including the risk of harm, the burden on the defendant, the connection between the defendant's conduct and the victim's injury, moral blame, and prevention of future harm. To impose the burden of around-the-clock supervision of its playground on the school district would impose a severe financial burden. Furthermore, there exists no special circumstances imposing a duty upon the school district to supervise and control activities unrelated to school functions. So that was a 1978 case, and it might be decided differently today, but the author of the article had a comment as follows. Under California Government Code 835, and we're going to be talking about the government code later because we're going to talk about how you make a claim if your student is injured at school, a public entity is liable for an injury caused by a dangerous condition on its property if the plaintiff can show that the property was in a dangerous condition at the time of the injury, that the dangerous condition proximately caused the injury, that the type of injury sustained was reasonably foreseeable, and that either the dangerous condition was created by the negligence or wrongful act of an employee of the public entity within the scope of his employment, or the public entity had actual or constructive notice of the condition and sufficient time in which to have taken measures to guard against it, and so on. So in this case, the finding was that the son sustained injuries as a result of his own conduct and not due to a dangerous condition of the property. And so it ended there.
Wow.
So, as you can see, a very difficult subject all the way around, and you can see how the parents would be aggrieved that their child had died at school, well, not during school, but on a school facility, and that the district people probably felt that it was unreasonable that they should be responsible for these activities during the time school was closed.
Absolutely.
So, am I out of time, or do I go on?
Well, we've got about 2.5 more minutes.
All right, well, let me just talk about this. I was only going to talk about two decisions just to give you a feeling sort of for how these things go. This is another California case, again, Daly versus Los Angeles Unified School District from 1972, Cal 3rd, 741, 1970. So the general rule of law was that school personnel supervising the conduct of students must exercise the degree of care a person of ordinary prudence charged with comparable duties would exercise. So in this case, and unfortunately I have to say, the two cases that I picked both involved adolescent or teenage boys. During recess, Michael Daly, a 16-year-old student at Gardena High School, was slap boxing with another student in the boys' gymnasium. They boxed for 5 to 10 minutes. A crowd of approximately 30 students gathered to watch. By the way, slap boxing is in quotes. And so I guess that's slapping, not boxing.
Okay.
Suddenly after being slapped, Michael, the decedent, fell backward and fractured his skull on the pavement. The Dalys, Michael's parents, filed a wrongful death action for damages, alleging that the district's failure to supervise the students caused their son's death. The physical education department was responsible for supervising the gymnasium. The chairman of that department stated that he did not know he was to assign a teacher to supervise on any particular day, that there was no formal schedule of supervision times, and that the supervision was left to whomever was in the gym office. At the time of the incident, the chairman was in the office playing bridge.
Ooh.
Ouch. The trial court granted the district's motion for a directed verdict and Daly appealed. So very quickly, the holding was that in this situation, school personnel supervising the conduct of students must exercise the degree of care a person of ordinary prudence charged with comparable duties would exercise. There's enough evidence here for a jury to find that the district failed to meet this standard. The responsible department failed to develop a comprehensive schedule of supervising assignments. Those who did supervise were not informed of their specific duties. The person in the gym office at the time of the incident did not attempt to maximize his ability to oversee students' activities. From these facts, the jury could reasonably find that the school personnel, school personnel failed to satisfy their duty of care causing Michael's death. The directed verdict, therefore, was improper, reversed. And just very quickly, Daly illustrates one of the many contexts in which courts are increasingly willing to impose a duty of care upon defendants to protect from harm those with whom they are in a special relationship. The duty may be imposed and the defendant found negligent, even where, as here, an intervening negligent or intentional act appears to be the traditional proximate cause of the injury. So I do want to say that part of what you see happening here is that although the other student was clearly liable, I think part of the strategy was to try to create a way to go after the school district because they're the ones that have a policy of insurance, right, not the family. But that's another discussion for another time.
Wow. Okay, well, you filled our head with some things that we need to think about. We'll pick it up today or next week.
Probably you need to go get a cup of coffee.
Right? I mean, none of us wants to really spend a lot of time on these kinds of stories, but it is important that we know what the law is, and because we're taking our children and dropping them off, so it is important to know. So,
well, and I would also add that it's important because some of us have children with autism who end up being accused of committing crimes at school when that's really not what they are doing or intend to do. And so I figure it's valuable for people to understand the legal framework. school districts are very, very worried about being sued for negligence. And they come down hard on kids because they get sued and they have a lot of problems associated with those lawsuits. So anyway, next week, we're going to talk about, or actually, next time, we're going to talk about how you file a government claim if your child is injured at school.
All right. Plus, we'll take questions so people can write those in. We want to thank you for being with us. Please tell us how we get a hold of you at Heerjee and Chow again.
Well, Heerjee and Chow's phone number is 310-391-0330. Our website is www.lawyer4children.com. And if you're in Southern California and you want a complimentary consultation, if you give us a call, we can set that up for you. Thank you again, Shannon.
Thank you so much for being with us. Hey, thanks for watching Autism Live. To subscribe, click here. And if you'd like to check out some more of our videos, click here.